Section 32 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. 2. Public disclosure of $232,500 to numerous Nixon committees. A. The contributions. The late-night meeting on March 24, attended by Chotiner, Nelson, and Kalmbach, was followed not only by the price support announcement, but also shortly thereafter by 100 committee names being sent to the milk producers for a $250,000 contribution to the president's campaign. By April 1, 1971, the effective date of the new price support level, Nelson had received from Marion Harrison a list of the committee names. Although Nelson testified that it was his understanding and intent that all three dairy trusts would contribute to those committees, he acknowledged that TAPE, the largest and most active, was to contribute the major share. Accordingly, on April 26 and May 3, 75 TAPE checks, each for $2,500, were drawn to 75 of the committees on the list. Footnote: Lilly first provided to the Select Committee in November 1973 copies of TAPE check stubs for 13 voided checks. Later, records of the remaining 62 checks were discovered. End footnote. However, these checks were never delivered and later were voided, and the contributions were not completed until July 1971 and thereafter. The delay in consummating the contributions was attributable not to the milk producers, who, following the favorable price support decision, were apparently anxious to honor their commitments, but to those responsible for the work of organizing the committees, which included drafting a charter, selecting a chairman and treasurer, and opening a bank account. As discussed in Section 4E, Robert Bennett had been given that primary responsibility by Colson and Kalmbach. Bennett says that he received a copy of the charter form for the committees from Thomas Evans, who in turn had received it from John Dean in March 1971. When Lee Nunn, the former director of the Senatorial Campaign Committee, joined the staff of the Citizens Committee for the re-election of the president in April 1971, the committees were not yet formed, and Nunn says that one of his first assignments was to help Bennett organize the committees. In his discussions with Kalmbach and with Hugh Sloan, who was treasurer of the Citizens Committee and later of FCRP, Nunn learned that several hundred committees would be needed ultimately for milk producer contributions, but that 100 committees were needed immediately. However, the process of forming the committees proceeded slowly even after Nunn and Sloan began helping Bennett. White House aides discussed the expected milk producer contributions and expressed concern over the delay in the formation of committees. Since the contributions were expected to be substantial, $2 million, and to be made in regular monthly installments of $90,000 beginning April 1, 1971, Haldeman considered them a, quote, good funding base for the setting up of the Citizens Committee, unquote, which had been organized in March 1971, just a few weeks earlier. In fact, on May 18, Haldeman and Dean met and decided that, quote, the milk money can pay for the 1701 activities up to the campaign, end quote. Footnote: It was estimated at the meeting that those expenses would run approximately $35,000 to $40,000 per month, or slightly less than one-half of the milk producer's monthly commitment. However, Sloan says that the monthly expenses were at first approximately $50,000 to $100,000, and by the fall of 1971, $200,000 to $300,000 per month. End footnote. However, based upon the recommendation of Kalmbach, Nunn, and Strachan, Haldeman decided several days thereafter not to use the "milk money" to pay for campaign expenses because both Kalmbach and Nunn were afraid of the "risk of discovery." But Strachan says that even after he made the decision, Haldeman was still anxious to receive the "milk money." Despite Haldeman's reported concern with the expected dairy contributions, he stated: Mr. Sanders. And the gist of your testimony, then, is that the milk producers had a desire to contribute to the reelection of the President and had made known the specific level of contribution, but that this was totally unrelated to any favorable action taken by the government or to be taken by the government. Mr. Haldeman. That is my specific understanding of what the basis of their intent to contribute was, that it was not to be considered to be related to any action or any desired action or any completed action by the government. Mr. Sanders. That is all I have. Mr. Dorson. In that connection, Mr. Haldeman, you mentioned one occasion when you believed the subject was raised as to whether there might be a quid pro quo for the contributions, and I believe you said it was made clear to you that the dairy industry expected no quid pro quo. Mr. Haldeman. I don't think I said. My recollection is not that the question was raised of whether there was a quid pro quo, but rather that the positive was raised. The point was made that it was to be understood that there was no quid pro quo. There was no commitment contingency. Mr. Dorson. Did this come up once or more than once? Mr. Haldeman. I think probably more than once. Footnote. As noted in section 3B above, Haldeman noted, obviously an offer of a $2 million contribution is a matter of interest, and the question, if not spoken, automatically arises as to why. End footnote. Although the $75 $2,500 checks from tape discussed above had been drawn and, according to a memo from Strachan to Haldeman, transferred as of May 21 to the Nixon committees being formed by Bennett, another 2 to 3 months passed before the committees were in proper form, apparently necessitating the voiding of those checks and rewriting of them later. Accordingly, the process of sending Nixon committee names to the milk producers began all over again in June. On June 16, Harrison sent a letter to Nelson with the names of 25 of the 100 committees and the name and address of each chairman and treasurer. As noted above, Harrison's letter expressed his apparent frustration over the process. Quote, sometimes it is difficult to honor a commitment. End quote. 2 weeks later, on June 29, Harrison sent to Nelson information on more committees. Since, as Harrison pointed out, these additional committee names were all included in the original list Nelson had received in April, Harrison urged Nelson to make the contributions immediately. Quote, it might be good politics to move fast. End quote. Harrison may have been concerned that, through no fault of their own, the milk producers had not been meeting their commitment, a fact of which, as discussed below, the White House did take notice. In any event, Nelson did, quote, move fast. On July 9, Isham sent 50 tape checks to Harrison in the amount of $2,500 each, for a total of $125,000, and made payable to the 50 committee names sent by Harrison. Harrison gave the checks to the Citizens Committee, and they were deposited in the accounts of the 50 respective committees in August. The second round of contributions to the remainder of the 100 committees, this time by all 3 trusts, was made in August and September 1971. Harrison testified that when he sent the names of the committees to Nelson, he sent copies to the other 2 co-ops, Mid-Am and DI. When the expected contributions were not immediately received, Harrison enlisted the assistance of his colleague Murray Chotiner. Footnote. Both Chotiner and Harrison have said that Chotiner was not involved in the mechanics of the contributions until that time. However, Chotiner was certainly instrumental in the meeting on the night of March 24 leading to the contributions, and according to the May 21 memo from Strachan to Haldeman, Chotiner communicated with none about the progress on organizing the committees and transferring those first 75 checks to the committees. End footnote. Chotiner says that before Harrison left in early August for a trip to Europe, Harrison told him that the money was not coming in as planned. Chotiner confirmed this with the Citizens Committee, presumably none, and then called Parr, who told him that the milk producers didn't have the necessary committee names. On August 5, 1971, Chotiner sent to Parr and Isham a list of names of 100 committees which had finally been organized, including the 50 to which Tape had already contributed. Immediately thereafter, Parr distributed the 49 remaining names to the 3 trusts. Footnote. Only 99 of the 100 committees were to be used. The 100th was chaired by E. Howard Hunt, and Bennett says it was decided that in view of Hunt's work at that time on the White House Plumbers Unit, it would have been inappropriate and too risky to link him publicly to the multiple committees and the president's campaign. End footnote. 25 to Isham, 12 to Gary Hanman of Mid-Am, and 12 to D.I. Footnote. The committee subpoenaed the relevant records of AMPI, Tape, DI, and Space, but was not provided with any written record of how or when the 12 committee names were sent to DI. End footnote. On August 19 and 20, both Space and Adept sent their checks to Chotiner. Space contributed $30,000 to the 12 committees assigned to it, but Adept contributed to only 6 committees for a total of $15,000. In a letter to Parr on the same day, Hanman explained that, quote, "Our balance in the fund was insufficient to handle all 12 committees." End quote. The following month, on September 10, Tape contributed its $62,500 to the remaining 25 committees. Of the $232,500, Tape contributed $187,500 to 75 committees to complete its portion of the contribution it had undertaken in April, Adept $15,000 to 6 committees, and Space $30,000 to 12. B. Rosemary Woods' list. The $232,500 contribution by the milk producers to the 100 secret presidential committees was important enough to merit separate attention by the president's personal secretary, Rosemary Woods, by being placed in a separate category in a campaign report to her. In the list of large contributions to the president's campaign prior to April 7, 1972, and kept by Woods, there is a separate page with the following information. House account, MP, $232,500. Milk Producers Association, TAPE, P.O. Box 32287, San Antonio, Texas 78216. ADEPT, Springfield, Missouri. SPACE, Kentucky Trust, 508 Portland Building, Louisville, Kentucky, 40202. Hugh Sloan, FCRP Treasurer, says he prepared several lists of large pre-April 7 contributors for use in soliciting monies for the campaign after April 7, and that he gave one copy to Stans, chairman of FCRP. Although Rosemary Woods, in an executive session before the Select Committee, said that she could not even identify a copy of the list shown to her, she did testify that she received such a list in the latter part of June 1972. Neither she nor Sloan nor anyone else connected with the fundraising effort interviewed by the committee could explain what was meant by the, quote, house account, unquote, for the milk money. Despite her custody of the list of contributors, which, according to Sloan, was used for fundraising for the duration of the campaign, Woods denied ever having had, quote, anything to do with raising of political campaign funds, end quote, and claimed that she kept the list only for invitations to White House dinners. However, Sloan says that a list of contributors for White House invitations was put together in 1973 when the campaign was over, not in mid-1972, when Woods says she received the list. In fact, a question is raised as to whether her custody of a list of large contributors and the amount of their contributions, even for the purpose of extending White House dinner invitations to such persons because of their large contributions, was inconsistent with the president's announced policy of not being informed of contributions to his campaign until after the election. C. Public disclosure. White House aides were concerned about disclosure of a link between the milk producers' contributions and the president's campaign, and they took certain precautions to minimize the possibility of such disclosure. Ultimately, their efforts proved unavailing. Since District of Columbia political committees were not required to report their expenditures, including any transfers to the president's campaign, the Bennett committees were organized in the District of Columbia to receive the dairy contributions. As previously noted, the dairy trusts reported to the clerk of the House, but the ultimate beneficiary, the president's campaign effort, was not disclosed in the trust's reports. Furthermore, the committees were made to appear as anonymous as possible. For treasurers of the committees, Bennett enlisted employees of the 2 banks in Washington used for the 100 committee accounts, and the bank addresses were designated as the official addresses for the committees to be included in reports to the clerk of the House. The names of the committees did not include the president's name and were drawn in such a way so as not to be linked to the president, such as, quote, Americans United for Honesty in Government, end quote. Footnote. In fact, Nelson requested an opinion letter from Harrison before making any contributions, and Harrison complied on July 8, the day before TAPE contributed $125,000, saying that the committees were bona fide and were to support the re-election solely of the president. End footnote. Despite all their efforts, the link between the milk contributions and the president's campaign was uncovered. Apparently because the milk producers erroneously reported the address of the chairman of several committees rather than the bank addresses given for the treasurers, some of the chairmen were contacted by investigators, and it became known that the committees were established by Bennett for the president's campaign. In addition, 2 persons who had originally been included as chairman and then replaced by Bennett were inadvertently included in the list sent to the milk producers and subsequently included in their public reports. These individuals then informed the clerk of the House that they knew nothing of the committees that had been reported as receiving the contributions. The milk producer reports were corrected, but the publicity linking the president and the milk producers had begun, and White House officials and fundraisers were quite upset. Internal White House memorandums in September 1971 indicate that Haldeman, Dean, Colson, Kalmbach, Nunn, Strachan, Bennett, Evans, and Robert Odell, executive director of the Republican National Finance Committee, met and discussed the investigations and stories by several newsmen on the milk money situation. According to one memo, Bennett advised Nunn that, quote, no damaging information has been released, end quote. But the damage had been done. Newspaper articles appeared which suggested that a quid pro quo may have taken place for the president's milk price support decision, and all parties to the transaction, the milk producers, the White House, and Bennett and his chairman, were embarrassed. Sloan says that accordingly, sometime in the fall of 1971, Harrison put a hold on additional contributions by the milk producers. Later, in late 1971 and early 1972, after the September contributions from TAPE were reported, more adverse publicity arose, and as a result, Bennett had the committees closed and the funds transferred to FCRP, and the milk producers began looking for other, less embarrassing ways to meet their commitments to the president's campaign. Their efforts in that connection, including meetings in 1972 with Kalmbach, Connolly, and others, is discussed in Section 6. 3. 1971 AMPI Convention and the President. After most of that $232,500 had been contributed by the milk producers, and just prior to the September 10 contribution of $62,500, the President attended and addressed AMPI's annual convention in Chicago on September 3, 1971, fulfilling one of AMPI's 3 objectives described to Kalmbach 2 years earlier. After Nelson and Parr personally escorted the President to the podium, the President spoke for 35 minutes to a crowd of approximately 40,000, during which he warmly congratulated the dairymen. "You have pioneered in developing a total marketing concept, which, I think, many other producers would do well to consider. And all of this you have done on your own, neither whimpering helplessly about uncontrollable economic forces, nor waiting passively for government to bail you out." Almost simultaneously with the President's address, 2 other events were taking place. The White House plumbers were breaking into the offices of Daniel Ellsberg's psychiatrist in California, and the milk producers were delivering to Harrison at the convention another $5,000 contribution for the President's campaign, which was used to pay for the break-in operation, as discussed in the following section. 4. Funding the Ellsberg break-in. A $5,000 contribution from the milk producers to the President's campaign was solicited and then diverted by Colson to pay for the Ellsberg break-in. Those involved in the transaction included Nelson, Chotiner, and Harrison representing the milk producers, George Webster, a Washington attorney, and Joseph Baroudi, a Washington public relations consultant. Each denies that he knew of the disposition of that contribution. A. Joseph Baroudi and AMPI. Joseph Baroudi is a partner in a Washington public relations firm of Wagner and Baroudi, which was retained at Colson's insistence by AMPI and paid $40,000, apparently without providing any services whatsoever, at least not to AMPI. Testifying on December 19, 1973, before the Select Committee, Nelson says that in late 1970 or in January 1971, when Nelson was meeting with Colson from time to time and discussing the $2 million pledge as well as AMPI's requests, Colson recommended to Harrison that AMPI hire Wagner and Baroudi for public relations work for $25,000. Since Nelson did not see any need for their services, he refused. Footnote: AMPI records reflect that no bills were submitted from Wagner and Baroudi until December 31, 1970, at which time bills for the last 3 months of 1970 and for January 1971 were submitted. It is possible, therefore, that the arrangement was not made final until December, with the proviso that Wagner and Baroudi would obtain $7,500 as a result of back billing. End footnote. Colson then repeated his request to Harrison and urged that AMPI hire the firm. Nelson testified that this time he complied. Mr. Nelson: And we decided that we had better do it. Mr. Weitz: Why? Mr. Nelson: Well, because it had been suggested by Mr. Colson was the only reason. Mr. Weitz: Did you feel that if you did not hire the firm at Mr. Colson's repeated request, that you somehow might lose some favor, or it might impede your efforts with Mr. Colson? Mr. Nelson: Yes. AMPI's records show that Wagner and Baroudi was paid $2,500 a month from October 1970 through January 1972, until the change in AMPI management, for a total of $40,000. Nevertheless, Nelson says that the Baruti firm not only failed to perform any services for AMPI, but even failed to meet with anyone from AMPI. Nelson called the $40,000 paid from corporate funds a, quote, contribution. Although Baruti says that his firm, quote, was expected to look for ways in which we could advance the interests of AMPI, end quote, he cites no work performed for the co-op for the fees. A question arises as to why Colson might have insisted on AMPI hiring the Baruti firm, and what use was made of the $40,000. As discussed above, Patrick J. Hillings, counsel to Harrison's firm, wrote to the president on December 16, 1970, at about the same time that Baruti's firm was put on retainer to AMPI, that AMPI was, quote, funding a special project, end quote. No one interviewed by the committee, including Hillings and Harrison, who composed the letter, could explain what was that, quote, special project. However, Baruti has acknowledged that he received monies from Colson on several occasions for certain projects. In 1971, Baruti received more than $3,000 to use in preparing television responses to a Common Cause statement on ending the Vietnam War, and in the spring of 1972, he received $22,000 from Colson to run newspaper advertisements in support of the president's Southeast Asia policies. Footnote: Baruti says that he returned the $22,000 when the project was suspended, and later he was given $6,800 to pay for a similar but scaled-down project. End footnote. From August 1971 until the spring of 1972, Baruti worked with the private committee organized at Colson's direction, Citizens for a New Prosperity, in support of the president's economic policies, including Phase 1 and Phase 2. Footnote: Colson testified before the state grand jury investigating the Ellsberg break-in that he often provided money from outside interest groups at the request of Haldeman or Ehrlichman for special White House projects. End footnote. One White House project that was funded by AMPI was the covert entry by the White House plumbers into the office of Daniel Ellsberg's psychiatrist Dr. Lewis Fielding on the night of September 3, 1971. Headed by Eagle Crow, the White House plumbers had been organized in July 1971 to investigate the source of the leaks of sensitive information highlighted by the newspaper publication of the so-called Pentagon Papers on the Vietnam War. The activities of the plumbers included an investigation of Daniel Ellsberg, who had been accused of leaking the papers to the press, and that investigation extended to matters such as uncovering and publicizing certain aspects of Ellsberg's background and private life, including his psychiatric records. Footnote: Colson pleaded guilty to one count of obstructing justice in the trial of Dr. Daniel Ellsberg. End footnote. According to Colson, Ehrlichman called him from the West Coast the week before Labor Day 1971 and told him that Crow needed $5,000 quickly for one of their projects. As recalled by Ehrlichman, he referred Crow to Colson for the necessary funds and did not personally telephone Colson. In any event, Colson has testified that he called Baruti, with whom he had already begun to work on the Citizens for a New Prosperity project, and asked him for a loan of $5,000 within the next day or two. Baruti says he immediately obtained the $5,000, $1,500 to $2,000 from personal funds, and the balance from funds Colson had given to him to use in preparing television responses to a Common Cause statement on ending the war in Southeast Asia. The next day, he took the money in an unmarked envelope to Colson, who directed him to deliver it to another individual whom Baruti didn't know at the time, but whom he now believes was Crow. The money was apparently given to Hunt and Liddy and went directly to pay for the expenses of the break-in. While Colson was arranging for the delivery of the money to Crow, he was also taking steps for its repayment to Baruti by contacting Chotiner and George Webster. B. Repayment for the break-in. George Webster was the director of the National Lawyers for Nixon organization in the 1968 campaign. In 1971, he organized committees at the request of Colson, ostensibly to receive contributions to the president's 1972 campaign. In fact, one of the committees, People United for Good Government, was used to furnish a $5,000 milk producer contribution to pay for the Ellsberg break-in. Webster's involvement with Colson began in early 1971, when Colson, whom he met in 1970, asked him to form 17 political committees in the District of Columbia to receive a $51,000 contribution, $3,000 per committee. Webster secured 4 friends to serve as committee officers and organized the committees. Footnote: Webster, who served as chairman of 4 of the 17 committees, asserted that although he received all 17 checks from Colson, he did not organize the remaining committees. However, the 4 other chairmen told the committee staff that Webster had prepared the necessary documents and that they did nothing more than sign the documents. End footnote. The money was subsequently transferred to another District of Columbia political committee fund, part of which went to the president's re-election campaign. Footnote: Webster says that sometime after the checks were deposited, Colson called him and asked that checks be drawn and made payable to the Republican National Committee, and Webster says that with respect to his 4 committees he did so. However, according to the other chairman, Webster arranged for the transfer at the time the committees were formed. These checks were not, however, received by the RNC, but were instead deposited in the account of a District of Columbia political committee, the D.C. Republican Support Committee. Webster assured the committee staff that the checks drawn on the committee accounts were delivered promptly because, quote, "as a lawyer, you don't leave things sitting around too long," end quote. Someone did, because the checks were not negotiated for 6 months. According to the bank records of the committees, the 17 checks were deposited in their respective committee accounts on February 9, 1971, and the 17 checks to the RNC drawn on these accounts were dated February 22, 1971, but were not negotiated until August 20, 1971, when they were deposited in the account of the D.C. Republican Support Committee. Before that committee was closed in February 1972, its funds were distributed to a number of political committees, including the Illinois FCRP. End footnote. Webster again accommodated Colson later in 1971. Webster says that in early September 1971, Colson called, asked if one of the 17 committees was still in existence to receive another contribution, and explained that he wanted to deposit some money in one of them. Several of the 17 committee accounts were still open, and Webster gave Colson the name of one of the 4 committees of which he was chairman, People United for Good Government. Colson, who had obtained $5,000 from Baruti for Crow at Ehrlichman's request, then arranged with the milk producers to repay the $5,000 to Baruti through Webster's committee. Chotiner says that Colson contacted him and asked if his client, AMPI, would contribute another $5,000 over and above the contributions to the 100 committees for some, quote, project. Chotiner says he relayed the request to Harrison, who then called Colson or Henry Cashin at the White House to work out the details. Harrison says, quote, "I was pleased to get the name of a committee. I thought Mr. Colson was doing us a favor, which had a prominent lawyer as a treasurer," end quote, and he passed the request on to AMPI. A $5,000 tape check was issued on September 2. Although he does not remember, Harrison says he may have received the check at the AMPI convention during the next day or so, when the president spoke, and he then delivered the check to Webster on or about September 7. The last step was to transfer the money to Baruti. Webster says that Colson called him about 10 days later and told him that he wanted the $5,000 in cash. Webster cashed a check on the committee account for $5,000 on September 21 and put it in his safe. According to Baruti, he received a call from someone in Colson's office sometime in September and was told to go to George Webster's office to get the cash, which he did. Webster, who was out of town at the time, had told his secretary to follow Colson's instructions. Colson, or someone in his office, had told her to give the money to Baruti, and when he came, she did so. Although Webster says that he assumed that the $5,000 was, quote, just like the other $51,000 that was going to the Republican National Committee, unquote, he conceded that he did not know, quote, where the funds went, end quote. He says that in any event he considered himself the trustee for Colson and felt his only obligation was to follow Colson's instructions. Footnote. Webster says he mistakenly thought that the Baruti who received the, quote, contribution was William Baruti, a brother of Joseph Baruti, who at that time was an official of the Department of Defense. End footnote. Later, Webster told Colson he didn't want to know the facts of the disposition of the money. In June or July of 1973, after federal and state grand jury investigations of the break-in had begun, Colson and his law partner, David Shapiro, met with Webster to discuss the transaction. However, according to Webster, when Colson started to explain that the money went to repay Baruti for the money he had extended to Crow, Webster cut him off by saying, "Chuck, you know you never told me. I assumed this money was going to the Republican National Committee at the time, and I have no knowledge about that. And whatever you did with the money was your own business." C. Haldeman and Ehrlichman approval of the milk producer repayment. There is evidence that the payback of the expenses of the Ellsberg break-in with milk producer contributions was carried out by Colson with the knowledge and approval of Haldeman and Ehrlichman. On September 11, 1971, 4 days after Harrison had delivered the $5,000 tape check to Webster, Strachan reported in a memorandum entitled, quote, Milk Money, to Haldeman that, according to Lee Nunn and Hugh Sloan, quote, Colson has established a separate agreement with the milk people in order to have cash available, end quote. The memo went on to say that, quote, if the alleged Colson agreement has your approval, the matter will be dropped, end quote. On the bottom of the memo were instructions from Haldeman to Strachan to check with Colson. Footnote. As described above, the White House has denied to the committee many documents relevant to the Milk Fund investigation. The September 11, 1971 memo, which referred to a $90,000 a month commitment and $232,500 in actual contributions from the milk producers, was not even included by the White House in the list of materials relevant to milk producer contributions. It was, however, appended to a motion by defendants in Nader v. Butts on January 18, 1974, opposing production by the president to plaintiffs of assertedly privileged documents. End footnote. Strachan testified that he raised the matter with Haldeman in the memorandum because Haldeman had been concerned about secret solicitation of contributors during the 1972 campaign by individuals in the White House without his knowledge, and that Haldeman had previously sent a memorandum to Colson, Magruder, Chotiner, and others instructing them to stop the practice. Strachan did check with Colson, and in a follow-up memorandum to Haldeman on September 16, also entitled, quote, Milk Money, Strachan reported, "You asked me to check Colson regarding an independent agreement with the milk people for Colson to get cash. Colson confirmed that he had made a separate arrangement to obtain $5,000. This money was committed by Ehrlichman, but never delivered in connection with a, quote, project we, Colson and Ehrlichman, worked on together, end quote. Footnote. This is consistent with what Strachan identified as his handwritten notes written on the September 11 memo and reflecting his follow-up activity. Quote, 5G separately on E committed siphoned, end quote. End footnote. Although Ehrlichman told the Select Committee staff that he did not commit the money for Crow, Haldeman testified that another of his aides, Lawrence Higbee, checked independently with Ehrlichman, who confirmed the accuracy of Strachan's September 16 report. Footnote. This is corroborated by a handwritten note following Strachan's report in the September 16 memo, quote, "Write L," end quote. End footnote. Strachan testified that Haldeman was apparently satisfied with Strachan's report and did not ask him for any further information or direct him to cancel the, quote, separate arrangement, end quote. End of section 32. Recording by Linda Johnson.
Section 33 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Paul Waldrop of Waynesville, North Carolina. Final report of the Senate Select Committee on Presidential Campaign Activities, Volume 2, Section 33. Chapter 6, Milk Producer Contribution Activity in 1972, prior to April 7th. The Justice Department antitrust suit against AMPI. By the end of 1971, the milk producers had received much of the favorable treatment from the president that they had sought. Low import quotas, higher price supports, meetings with the president, and the presidential address to their convention. But they had also been the subject of a great deal of unfavorable publicity in connection with their attempts to honor their commitment for contributions. In order to make additional contributions in 1972 without that attendant publicity, they recontacted Kalmbach and tried to develop a different procedure for those contributions. At about the same time, a Justice Department antitrust investigation of AMPI culminated in the filing of a civil suit. This action impacted upon the contribution activity of the milk producers, at first chilling their interest in making additional contributions, and, according to Kalmbach's testimony and other evidence, later, just prior to April 7, 1972, resulting in a last-ditch effort by AMPI to seek a cessation of the suit as a quid pro quo for more secret contributions to the president's campaign. A. The Justice Department antitrust suit against AMPI. In the late 1960s and early 1970s, the Antitrust Division of the Justice Department received a number of complaints from independent dairy farmers against MPI and then later AMPI, alleging that the cooperative had engaged in predatory practices to squeeze smaller cooperatives out of their markets in order to monopolize their markets. A staff investigation was initiated, which led to a recommendation for a grand jury investigation, leading to possible criminal prosecution. Attorney General Mitchell rejected that recommendation and limited the department's action to a civil suit, which was filed on February 1, 1972. 1. Department Staff Investigation and Recommendations. On February 23, 1971, the Justice Department authorized a preliminary investigation of AMPI's activities in the Dallas, Texas area, which soon expanded to a number of states in the central United States. Much of the original investigation was conducted by Rebecca Schneiderman, a trial attorney in the Chicago Regional Office of the Antitrust Division, who, after a several-month investigation, concluded that AMPI's activities were sufficiently anti-competitive to necessitate a grand jury investigation of the cooperative with a view to possible criminal prosecution. John Sarbaugh, chief of the Chicago office, concurred with Schneiderman and on August 11, 1971, requested authority to conduct a grand jury investigation of AMPI. The request was forwarded to the Antitrust Division in Washington, D.C., where it was reviewed and approved by a succession of officials, all of whom concurred in the recommendation of the Chicago office. These officials included Badiah J. Rashid, Director of Operations for the Antitrust Division, Gerald Connell, Chief of the Department's General Litigation Section, and Robert Hummel, Deputy Director of Operations. After the approval, the grand jury's request was sent to the office of the Assistant Attorney General for Antitrust, Richard McLaren, where it was reviewed by McLaren and his assistant, Walter B. Comegys. McLaren consulted with Assistant Secretary of Agriculture Richard Lang to determine whether the Department of Agriculture objected to a grand jury investigation of AMPI, and Lang indicated that the department had no objection. Both Comegys and McLaren then approved the request, and on September 9, 1971, 1 week after the President had addressed the AMPI convention, McLaren forwarded a memorandum to Attorney General Mitchell requesting authority for a grand jury investigation. McLaren says he normally received a response from Mitchell on such matters within a week or two. When by October 29, 1971, 7 weeks later, McLaren received no response but had continued to receive complaints from milk producers about AMPI's conduct, he sent Attorney General Mitchell a second memorandum requesting authority for a grand jury and emphasizing those allegations that AMPI was continuing its predatory practices. 2. Attorney General Mitchell's actions. On November 30, 1971, in a departure, according to McLaren, from department practice, Attorney General Mitchell rejected the request for a grand jury investigation of AMPI. In a one-line memorandum, he instructed McLaren, "Per our conversation, I request that you go the civil route," thereby limiting the case to a civil suit only. Although Mitchell does not remember the conversation or even turning down a request for a criminal investigation, he acknowledged that the memorandum must have reflected his decision. And Judge McLaren has stated that he did discuss the AMPI case with the Attorney General on November 30th. Apparently, in the course of their discussion, the Attorney General expressed the opinion that the Justice Department would have difficulty obtaining a criminal conviction in light of AMPI's defense that a federal statute applicable to farmer cooperatives, the Capper-Volstead Act, exempted its activities from the antitrust laws, and that AMPI could claim they relied on advice of counsel. However, from the very start of the investigation, the Antitrust Division was cognizant of the provisions of the Act and the argument that the statute exempted AMPI from the otherwise applicable provisions of the antitrust laws. Based upon a long-standing Supreme Court precedent, everyone concerned had rejected that argument except Attorney General Mitchell. In response to a recent staff request, McLaren stated that Mitchell's action was unusual and that he could not recall any other specific instance in which Attorney General Mitchell turned down a recommendation from the Antitrust Division. McLaren further pointed out that, to his knowledge, Mitchell had no particular expertise in this area and had no information that was not available to the Antitrust Division. Of the various alternatives available to the Justice Department under the circumstances in the case, a criminal prosecution, simultaneous criminal and civil suits, or a civil suit only, the Attorney General's directive to McLaren limited the department to the minimum action which the government will pursue when the evidence indicates an antitrust violation. In interviews with select committee staff, some of the staff attorneys in the Chicago office who had concurred in the appropriateness and need for a grand jury investigation stated that they were disappointed and surprised at the Attorney General's decision. Aside from other considerations, the decision to pursue the AMPI case as a civil suit had an impact on the subsequent investigation in the case. Normally, investigation of a civil suit is conducted by Civil Investigative Demand, CID, a cumbersome procedure which moves very slowly if the person or organization under investigation resists the demand for information and documents. A grand jury, on the other hand, has more extensive compulsory procedures, including the ability to subpoena testimony and documents relative to the case from the party under investigation or from third parties. Recognizing the limitations of the CID and the apparent urgency of the complainants, and perhaps in expectation of resistance by AMPI, McLaren directed the staff to obtain by interviews any further evidence needed to prepare a civil complaint, in addition to that accumulated during the preceding 9-month investigation. These instructions were carried out, and a civil complaint against AMPI was drafted, which alleged generally that the co-op had violated Sections 1 and 2 of the Sherman Act. Among the specific allegations of the complaint, it was asserted that AMPI had 1. Depressed the price which its competitors could receive for their milk by loading the pool while protecting AMPI members from economic loss. 2. Agreed that processors who purchase milk from AMPI would not purchase milk from competitors of AMPI or would pay a substantially higher price for their milk than those who did not deal with AMPI's competitors. And 3. Agreed that some processors would not sell or deliver milk acquired from AMPI to other processors except as directed by AMPI. The complaint also alleged that AMPI had acquired competing processors and haulers, and as part of its base excess plan, forced its producer members to sign membership agreements forbidding the producers from competing with AMPI for a period of 5 years after terminating membership in the co-op. In late December 1971, the Chicago office sent a copy of the proposed complaint and a memorandum summarizing the evidence to support the suit to Washington. On January 18, 1972, following review of the case in the Antitrust Division, including the making of minor changes in the complaint, McLaren met again with Assistant Secretary Ling and showed him a copy of the proposed complaint against AMPI. Ling stated that he had no objection to the complaint and that he would advise the Secretary of Agriculture of McLaren's proposed action. McLaren then forwarded the complaint and fact memorandum to the Attorney General, with an accompanying note in which he stressed AMPI's grossly predatory practices and strongly urged the Attorney General to approve the suit. On January 22, 1972, Attorney General Mitchell approved the complaint and sent it to McLaren with a note which said, "I suggest you get these people in before you file." McLaren says that Mitchell specifically directed him at that time to give AMPI the opportunity to enter into pre-filing negotiations. The committee received conflicting evidence on the regularity of undertaking pre-filing negotiations. Pre-filing negotiations are undertaken in an attempt to have the parties agree to a consent decree, which is then filed with the complaint in settlement of the case. While according to McLaren, pre-filing negotiations are very common, and it is not unusual for the Antitrust Division to inquire of the prospective defendants whether they wish to pre-file in all cases, other Antitrust Division officials told the committee staff that they viewed pre-filing negotiations to be appropriate only when the defendants have agreed in principle to the terms of the relief sought by the government in its complaint. Although it apparently was not unusual for Mitchell to send notes to McLaren on a variety of subjects, and that at the time McLaren did not consider his written communication unusual or significant, Mitchell's written directive to McLaren must be viewed in the light of Mitchell's participation at that time, described in 6b below, to raise $1 million or more in campaign contributions for AMPI. Nonetheless, the division carried out Mitchell's order until it became clear that, after all, the AMPI case was an inappropriate one for pre-filing negotiations. 3. Pre-filing negotiations and the filing of the suit. On Monday, January 24, 1972, Sarbaugh contacted Stuart Russell, one of the counsel for AMPI, and informed him that the Chicago office had been authorized to file an antitrust complaint against AMPI and to ask AMPI if it wanted to engage in pre-filing negotiations, which might lead to a consent decree. Sarbaugh gave Russell until Thursday, January 27th, to respond, and in keeping with division practice, he stated that the government would permit the negotiations to continue for a period of time not to exceed 60 days. Otherwise, the complaint would be filed Friday, January 28, 1972. In response, Russell told Sarbaugh that AMPI would probably want to negotiate, and that he would contact AMPI's Chicago counsel, Martin Burns, who would most likely contact the Chicago office to see the complaint. On Tuesday, January 25, 1972, Burns read the complaint, and on January 26th, he called to say that AMPI wanted to engage in pre-filing negotiations. On January 27, 1972, at a meeting with the staff at the Chicago office, Burns and his partner, Erwin Henninger, confirmed AMPI's intention to engage in pre-filing negotiations. However, it soon became clear that AMPI was not prepared to agree in principle to the relief requested by the government, the threshold requirement for the negotiations to continue. For example, according to Sarbaugh, Henninger questioned the propriety of the civil antitrust complaint and stated his belief that a number of AMPI's alleged activities were exempt under the Capper-Volstead Act. There also seemed to be another component to AMPI's tactics in the negotiations. At that point in late January, McLaren was scheduled to leave his post for a federal judgeship in less than a week. The 60-day pre-filing negotiations, if completed, would extend well beyond the time of his departure. Sarbaugh says that at the January 27th meeting, Henninger mentioned that with McLaren leaving the department, the complaint would probably have to be signed by his successor before it could be filed. Henninger also referred to the fact that dairymen were big political contributors. Sarbaugh, who had known Henninger professionally for a number of years, was shocked and concerned by the reference to political contributions. He thought this was the most blunt and tactless comment he had ever heard Henninger make. Its meaning was clear, at least to Sarbaugh and McLaren. By stalling beyond the time of McLaren's departure, AMPI might be able to use the pre-filing negotiation period to block politically the filing of the suit. Although the meeting ended with the understanding that negotiations would continue, Sarbaugh made it clear to Henninger that the government was not committed to pre-filing negotiations for the full 60-day period, and that the complaint would be filed if, at any time, the parties reached an impasse in the negotiations. Sarbaugh was concerned about Henninger's attitude toward the negotiations. He felt that there had been no real agreement by Henninger that AMPI would accept the relief sought in the complaint. He was aware that dairy cooperatives had been big contributors, and in light of Henninger's comments, he brought the matter to the attention of Assistant Attorney General McLaren, who instructed him to call Henninger and tell him that the Chicago office would give him a proposed consent decree by the close of business on Friday, January 28th. McLaren said that unless AMPI consented to the basic terms of the proposed decree by the close of business on Monday, January 31st, the suit would be filed the next day, February 1st. Sarbaugh relayed the message to Henninger and told him that the AMPI case was not an appropriate case for pre-filing negotiations, since AMPI had not requested the negotiations in the first place, and that AMPI had not agreed in principle to the relief requested. The proposed final judgment was submitted to Henninger at 3:30 on Friday afternoon, along with a letter requesting that AMPI make a written response before the close of business on Monday, January 31st. On Monday afternoon, Henninger called Sarbaugh and told him that AMPI could not meet the suggested deadline of the Antitrust Division since it could not resolve all of the problems raised by the proposed judgment before the close of business that day. The antitrust suit was filed February 1st, 1972, McLaren's last day in office at the Justice Department. B. White House involvement prior to the filing of the suit. McLaren's original recommendation for a grand jury in the AMPI case went to Mitchell on the very same date, September 10, 1971, that the milk producers were contributing the last $62,500 of the $232,500 to the multiple presidential campaign committees. During the next 2 months, while Mitchell was considering what action to take, White House aides began monitoring the antitrust investigation, and there is evidence that Mitchell conferred with Haldeman about the milk producer contributions and the antitrust problems before he turned down McLaren's recommendation for a grand jury investigation. There is also evidence that in January 1972, Mitchell was taking an active role in further solicitations of the milk producers, at the very time he directed McLaren to enter in pre-filing negotiations with AMPI. 1. Monitoring of the antitrust investigation by White House aides. Although a resolution of antitrust problems was not on the original list of milk producer objectives outlined to Kalmbach in 1969, it was a subject of discussion between them and the White House in 1970 and 1971. Jack Gleason says he remembers meeting with Nelson and Parr in early 1970 and discussing their concern over possible trouble from the Justice Department. Henry Cashin, one of Colson's assistants, told the committee staff that sometime in 1971 or 1972, Marion Harrison told him that the dairy people were going to get clobbered by the Antitrust Division. Cashin says that since Justice Department matters were the responsibility in the White House of John Dean, he may have passed on the information to Dean, and because of Colson's interest in the milk producers, to Colson too. On September 24, 1971, 3 weeks after the president spoke to the AMPI convention and 2 weeks after the $62,500 contribution was made and McLaren's recommendation went to Mitchell, Colson sent a memo to Haldeman, Eyes Only, entitled Milk Producers, with the following information on the antitrust investigation. There is underway in the Justice Department at this moment an Antitrust Division investigation of the milk producer cooperatives. Attached is the 1956 court decision exempting the milk producers from applications of the antitrust laws. If this goes too far, there will be a number of very serious adverse consequences, which I would be glad to elaborate on in detail. Haldeman says that he does not know what serious adverse consequences Coulson meant, and does not remember any White House concern about the antitrust investigation, despite the continued interest evidenced by the president and his staff over milk producer support for the president's re-election effort, and despite the negative impact that criminal prosecution of the co-op and its leaders would be expected to have on that support. Haldeman apparently did want at least some further information on the matter, because on October 6th, Dean sent to Haldeman aide Gordon Strachan the information you requested, a report on a possible antitrust exemption for AMPI and the current activities within the Department of Justice concerning AMPI. At that point, the current activities included the recommendation for a grand jury investigation, which was awaiting Mitchell's approval. In his September 24th memo to Haldeman, Coulson indicated that he wanted to stay out of it, and he suggested that the antitrust investigation should be taken up at one of your meetings. Haldeman apparently discussed the matter with Mitchell at a subsequent political matters meeting. 2. Haldeman-Mitchell meeting. There is evidence that Mitchell was deeply involved in the president's campaign long before he resigned as Attorney General, and that he regularly met with Haldeman, presidential assistant and later deputy campaign director for CRP, Jeb Stuart Magruder, and others to pass on campaign matters. One political matter scheduled for discussion at such a meeting was the antitrust investigation of the milk producers. On November 4, 1971, 6 days after McLaren's second memorandum to Mitchell repeating his recommendation for a grand jury investigation, a political matters meeting was held, attended by Haldeman and Mitchell, and for a part of the meeting, Magruder and Strachan. In preparation for the meeting, Strachan prepared an agenda of subjects to be discussed, and a talking paper briefly detailing each subject. The agenda was distributed to all 4 attendees, but the talking paper was distributed to only Haldeman and Mitchell and not Magruder. Item 15 of the paper indicates that the department's antitrust investigation of the milk producers was to be discussed, as well as milk money. 15. As you probably know, the milk producers currently enjoy an antitrust exemption resulting from a 1956 decision by the Federal District for the District of Columbia. A report here at the White House indicates the Antitrust Division at Justice is now investigating that exemption. Another report indicates that the Washington Post has assigned 4 reporters full-time on the Milk Money Project. Do I understand correctly that you have directed John Dean to review any reports that have to be filed on the Hill connected with the receipt of the milk money? Neither Haldeman nor Mitchell remembers any discussion at that meeting of the antitrust matter. Mitchell does not even remember knowing that the milk producers who were the subject of the investigation were the milk producers who were making campaign contributions. There seems little doubt, however, that the subject was taken up. Strachan has testified that matters not covered in one meeting were taken up at the next, and the White House has not disclosed any agenda or talking paper for a subsequent political matters meeting in which the matter is listed. Although Mitchell denies it, the talking paper clearly suggests that the Attorney General was informed of the connection between the milk producers under investigation and milk money, and that Haldeman and the Attorney General discussed the investigation in the context of the campaign and milk producer contributions. The day before his meeting with Mitchell, November 3rd, and again on November 29th, the day before Mitchell's rejection of the request for a grand jury, Haldeman met with Choitner, who was counsel to the milk producers. Haldeman does not remember discussing the antitrust suit with Choitner at either of these meetings. 3. Other Mitchell contacts. Mitchell also met with Kalmbach several times during the September 10th to November 30th time period, while the McLaren recommendation lay on his desk. Although he does not specifically recall speaking to him, Mitchell said in a staff interview that the only person other than Kalmbach with whom he may have discussed the antitrust suit was Choitner. On November 18th, according to Mitchell's logs, he had a series of afternoon meetings or conversations with Kalmbach and others who were familiar with the milk producers, although there is no evidence of what was discussed in those contacts. At 2:10, he met with Dean and Kalmbach. At 3:15, Harry Dent called him, and at 4:30, Haldeman called him. It appears that Mitchell then met with the president, because according to John Connolly's logs, Connolly received a call at 4:58 p.m. from Mitchell in the president's office. 12 days later, Mitchell rejected McLaren's request for a grand jury investigation. In early 1972, when McLaren went back to Mitchell for his approval of the civil complaint against AMPI, Mitchell was again making campaign decisions concerning AMPI. As discussed in the following section, Kalmbach met with AMPI officials in January and February of 1972 to make arrangements for the remaining contribution toward their campaign commitment. On January 13, 1972, the day before one such meeting, Kalmbach conferred with Mitchell, who is reported to have been informed and to have approved of the continued Kalmbach AMPI contacts to seek ways for the co-ops to fulfill their $2 million commitment. On January 21st at 2:30, Mitchell met with Kalmbach on the subject of campaign contributions. At that meeting, Kalmbach reported to him that he had met with the milk producers who had confirmed that the milk money will continue to come in. The next day, Mitchell approved the civil suit, but directed McLaren to begin pre-filing negotiations. McLaren has stated that he caused the AMPI suit to be filed on February 1st before he left the department because he felt that AMPI was not engaging in the negotiations in good faith and that he wanted to preclude any possible attempt by AMPI to resist the filing of the suit by some political means. In view of the White House involvement, Henninger's reference during the pre-filing negotiations to political contributions and Mitchell's previous decision in the case favorable to the milk producers, there was a basis for McLaren's concern over the progress of the negotiations and the ultimate filing of the suit. There is also evidence that in the months that followed, AMPI officials offered more substantial contributions to gain a favorable resolution of the suit. End of section 33. Recording by Paul Waldrop of Waynesville, North Carolina.
Section 34 of The Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. C. Fundraising meetings between AMPI and Kalmbach in January and February 1972. The Bennett committees were closed after the adverse publicity over the 1971 milk producer contributions, but there was still a large amount to be contributed by the milk producers to honor their commitment to the president's campaign, and Nelson wanted to honor that commitment. Instead of working through Harrison and Choitner, as he had done the previous year, Jacobson was asked to contact Kalmbach and work out a different set of arrangements, and as a result, several meetings were held between AMPI officials and Kalmbach in January and February. Footnote: Nelson apparently felt that Harrison had been ineffective in arranging for the 1971 contributions. End footnote. In the meantime, on January 12, 1972, Nelson was replaced as general manager of AMPI by George Merin, and 2 weeks later the antitrust suit was filed by the Justice Department against AMPI. 1. Kalmbach-Nelson-Jacobson meeting on January 14. Kalmbach was generally uninvolved in the milk producer contributions from the summer of 1971 until the end of the year. At that point, Jacobson contacted him, explained that he was a partner of Milton Seymour, who had delivered the $100,000 to Kalmbach 2 years before, and told him the milk producers wanted to meet with him again. A meeting was then arranged for Kalmbach, Jacobson, and Nelson for January 14, 1972, in California. Before the meeting, a major change was made in AMPI's top management. On January 12, the AMPI board voted to remove Nelson as general manager and elected George Merin, a former Assistant Secretary of Agriculture in the Johnson administration, and from 1968 until 1972, a consultant and then director of programming of AMPI. Nelson was given a 7-year consulting contract renewable annually at $100,000 per year, and over the next few weeks, Parr and several other AMPI officials and employees left AMPI. Within hours after his removal, Nelson went to Merin to ask permission to use the AMPI corporate jet for his trip to California to meet with Kalmbach on the 14th. Nelson says that he told Merin of the scheduled meeting, and Merin instructed him to follow through with it. Jacobson testified that before the meeting, Nelson told him that Merin had authorized him to meet with Kalmbach. Merin denies being told of the meeting, but acknowledges that he gave Nelson permission to use the jet, quote, to clean up odds and ends, end quote. On January 13, Nelson and Jacobson flew to California. When they met with Kalmbach the next morning, they told him that they wanted to continue the contributions in 1972 with as much money as possible, but hopefully without the type of publicity of the previous year. Footnote: although there is no record of the flight in the AMPI jet log, the committee has obtained records of hotel charges for Nelson and the pilots in the Los Angeles area for the night of the 13th, and of airport charges to AMPI for an airplane on the 14th. End footnote. They indicated that since Nelson had been replaced, Merin would have to be consulted before any final decisions were made. It is evident that both Haldeman and Mitchell were monitoring these contacts between Kalmbach and the milk producers. As mentioned above, Kalmbach had met with Mitchell on the 13th, the day before the meeting with Jacobson and Nelson. Kalmbach says that since Jacobson was a partner of Seymour, who had been active in the Muskie campaign, Kalmbach checked with Mitchell, who approved of him meeting with Jacobson and the milk producers to arrange for further contributions. Kalmbach also reported the results of the January 14 meeting to Strachan, who relayed the report to Haldeman in a, quote, political matters, end quote, memo on January 18. 1. Herb Kalmbach met with Messrs. Jacobson and Nelson on January the 14th concerning the milk money. Kalmbach had a, quote, good meeting. The money will continue to come in, but the milk people do not want to continue to deal with Reeves and Harrison, Chottiner's firm. Kalmbach would take over this project as a special assignment. He will ask the Attorney General on January the 20th. The Attorney General approved of Kalmbach meeting with Jacobson, even though Milt Seymour is Jacobson's law partner and treasurer of the Muskie campaign. Kalmbach informed Colson of the meeting, but would not tell Colson who asked him to see Jacobson. Kalmbach believes someone should give all information about the milk situation to Colson. I told him Colson was no longer involved. Recommendation: that you inform Colson of the milk situation, and that Kalmbach be asked not to discuss the milk situation with Colson in the future. Footnote: this document was requested by the committee, but the president refused to provide it. An excised portion of the document was made public in connection with the Nader v. Butts case. End footnote. As related by Kalmbach, there was a great antipathy between Colson and both Mitchell and Seymour because of Mitchell's and Jacobson's involvement. Strachan recommended to Haldeman that Colson not be informed of all aspects of the continuing solicitations of the dairymen. Footnote. Mitchell once called Colson, quote, "a walking time bomb," end quote. End footnote. Haldeman approved Strachan's recommendation and wrote at the top of the memorandum, quote, "Good job," end quote. According to Mitchell's logs, he next met with Kalmbach on January 21, when Kalmbach reported the results of the meeting to Mitchell. As noted above, this briefing took place the day before Mitchell approved the institution of a civil antitrust suit against AMPI while directing McLaren to delay the filing and begin pre-filing negotiations. 2. Kalmbach-AMPI meeting on February 3. By the time the next meeting in 1972 between Kalmbach and AMPI leaders occurred on February 3, three developments had taken place that would have an impact in subsequent meetings with Kalmbach. First, the Justice Department antitrust suit against AMPI, described above, had been filed on February 1. Second, a lawsuit had been filed by Ralph Nader and several public interest groups against the Secretary of Agriculture, alleging that the 1971 price support increase was illegal. Third, George Mehren had become involved in AMPI's political affairs. A. Nader v. Butts. On January 24, 1972, a suit was filed in the Federal District Court in the District of Columbia by Ralph Nader, Public Citizen, Incorporated, Federation of Homemakers and Consumers Association of the District of Columbia, against Secretary of Agriculture Butts, who had replaced Secretary Hardin in November 1971, and the Commodity Credit Corporation, alleging that the 1971 milk price support increase was not based on statutory grounds, but on political considerations, including contributions. The complaint further alleged that the increase was, quote, "unlawful and unenforceable," end quote, and sought a declaratory judgment and an injunction against continuing support at the $4.93 level. There was immediate reaction to the suit in the White House. On February 1, Dean sent a memorandum to Ehrlichman describing the suit and its background. Although he thought the suit could be defeated, he warned that, quote, "the discovery proceedings could prove disastrous," end quote. In particular, he pointed out that dairy industry officials, quote, "will certainly be questioned in detail," end quote, about, quote, "all commitments made by the President," end quote, at the March 23, 1971 meeting, and that in the course of their depositions, quote, "questioning about their duties with the committees and the manner in which the committees operate could prove highly embarrassing in an election year," end quote. Footnote. Also on February 1, Dean sent another memo to Ehrlichman notifying him that the antitrust suit had been filed against AMPI, quote, "the largest of the three cooperatives involved in the Nader case and the organizer of TAPE," end quote. End footnote. That same day, February 1, Strachan sent a, quote, "political matters," unquote, memo to Haldeman, in which he described Kalmbach's apparent concern about the Nader suit. Kalmbach is very concerned about his involvement in the milk producers' situation. Kalmbach will accept the risk of being subpoenaed by the court in connection with the Nader milk suit. The Attorney General believes Kalmbach should continue to handle the milk project, but Kalmbach wants your advice. Recommendation that Kalmbach not be involved in the milk project because of the risk of disclosure. Footnote. This document, along with a number of other White House documents referring to milk producer contributions, were denied by the President to the Select Committee. Some, but not all, of the documents, including an excised portion of the above described memo, were subsequently made public in the Nader v. Butts suit. In referring to White House communications to him from Colson, Strachan, and perhaps Dean on dairy money, commitments, the antitrust and Nader suits, and related matters, Haldeman observed that they, quote, tended to over-dramatize a lot of things and to lay more import on the language than they really needed, end quote. Haldeman tried to discount the, quote, colorful language, unquote, as he put it, of these White House memos, and explained that, quote, these were written as internal office memorandums, not as public documents, end quote. End footnote. Haldeman wrote on the memo, quote, I'll discuss with AG, end quote. Based on his notes written on the memo, Strachan says he relayed this comment to Kalmbach on the 3rd, the day of Kalmbach's next meeting with the AMPI people, and included this item in a talking paper he prepared for a Haldeman-Mitchell meeting on February 9. Footnote. The White House has omitted any reference to this alleged talking paper from its list of relevant milk documents. End footnote. As discussed below, White House plans to proceed with the milk producer contributions and Kalmbach's involvement were not changed until March, when the ITT scandal broke and it appeared to Kalmbach that the AMPI case, too, might involve a quid pro quo. B. George Mehren and the question of previous commitments of contributions. Although George Mehren had assisted Nelson in the dairy efforts to secure a price support increase in March 1971, he claims that when he succeeded to Nelson's position in January 1972, he did not know of any commitments for contributions to the president's campaign. Mehren explained that with the publicity in late 1971 over the price decision and dairy contributions, and with widespread rumors among AMPI members of commitments, when he assumed office, he did ask AMPI's former officials what political commitments were outstanding, but that no one told him any commitments existed, perhaps because they felt he would not have honored them. For example, Mehren had heard from AMPI employee Byford Bain that Parr had made a commitment to the president's campaign of $2.6 million. Mehren says that in the presence of John Butterbrodt, the AMPI board president, he asked Parr in early 1972 whether such a commitment existed. According to Mehren, Parr told him, quote, that no commitment had been made, and he further said that he was not acquainted with Mr. Colson, end quote. Mehren says he also asked Nelson and Jacobson, who he says denied knowledge of any commitments, but who advised Mehren to make further contributions by telling him, quote, we have to live with those people for another 4 years, end quote. Both Jacobson and Parr dispute Mehren and say that he never even asked them about a commitment, although Jacobson says he recommended on his own to Mehren that they make a substantial contribution. Moreover, there is evidence that Mehren knew of a commitment and reluctantly had decided to honor it. Nelson testified that there had been a commitment, which in January 1972 he felt had not yet been satisfied, and he says he told this to Mehren. In fact, Robert O. Isham, the tape trustee and AMPI comptroller, whom Mehren was consulting, says that in the first several months of 1972, Mehren indicated to him that he felt he was going to have to honor their commitments and contribute to the president's campaign. Indeed, Isham says he resigned from tape just prior to April 7 in order to avoid involvement in any such contributions. There is evidence that after Mehren was informed of the facts sometime between January 14 and the February 3 meeting with Kalmbach, the original $2 million commitment was scaled down to $1 million. In his February 1st memo to Haldeman, Strachan reported on Kalmbach's progress in raising funds from the milk people, including Kalmbach's belief that, quote, Jacobson and Nelson will deliver, though they have cut the original 2,000 commitment back to 1,000, end quote. Nelson testified that he reaffirmed at the January 14 meeting the original $2 million commitment, and as of January 18, Kalmbach had reported to Strachan no change in that commitment. Although he could not pinpoint the date, Kalmbach presumably was informed of the change between January 18 and February 1, during the period when Nelson and Jacobson were in touch with Mehren and then Kalmbach to arrange the next meeting between AMPI and Kalmbach. This evidence and that of the February 3 meeting and events thereafter indicate that Mehren, a lifelong Democrat and an official in the Johnson administration with no particular sympathy for the president's re-election effort, felt obligated under the prior commitment and was indeed prepared to meet that obligation, although in the context of AMPI's most recent problem, the antitrust suit. Footnote. In his testimony before the Select Committee, Mehren stated that with regard to the 1972 election, quote, "I would have had no great personal trauma if the Republicans would have lost in the Middle West." End quote. End footnote. C. February 3 meeting. On February 3, Mehren, Nelson, and Jacobson flew to California and met with Kalmbach and two of his law partners, Frank DeMarco, one of the president's tax attorneys and counsel to the California FCRP, and Robert Olson, now a California Superior Court judge. Although DeMarco, who had not previously met the milk producer representatives, does not remember any discussion of contributions, the others present agree that the making of substantial contributions by the dairy co-op was discussed. Footnote. In fact, Olson says some of the discussion of pre-April 7 contributions and committees took place with DeMarco present in DeMarco's office, and that Kalmbach perhaps wanted Olson and DeMarco present as witnesses. End footnote. After Kalmbach told Mehren that it was to be understood that there was no quid pro quo involved, Kalmbach told them that he understood they were interested in making a substantial contribution. According to Mehren, the discussion centered on a contribution of $750,000, and either Kalmbach or DeMarco suggested that most of the money, $700,000, could be contributed prior to April 7 and the rest later. Footnote. Jacobson says the pre-April 7 contribution was to be made in several installments, such as 1/3, 1/3, and 1/4 of the total $750,000 contribution. End footnote. It was indicated that, as opposed to the previous year, the pre-April 7 money would go to real committees with real officers in a number of states, but independent of the state Republican committees. Mehren says that the purpose of the procedure, as he understood it, was to avoid public disclosure of more milk producer contributions to the president's campaign. Although Mehren claims he objected to the suggested procedure, there is evidence that, as a result of the meeting and further contact with the AMPI people, Kalmbach fully expected substantially all the $750,000 to come in prior to April 7 to fulfill the amended $1 million commitment. Footnote. John Butterbrodt, AMPI's president, testified that Mehren subsequently told him that Kalmbach suggested the contributions be made to state committees and that the ultimate source, the president's campaign, would not be disclosed and would remain secret. He says that he and Mehren rejected that alternative. End footnote. In a February 16 Political Matters memo from Strachan to Haldeman, it was reported that, quote, Kalmbach is working with the milk people to increase the 233 currently banked to 1,000 by April 7. Footnote. Kalmbach says he was working out the details of the transaction with Jacobson after the February 3 meeting. End footnote. At the same meeting on February 3 that there was a discussion of contributions, there was also a discussion of a substantive problem. According to Jacobson, and as more fully discussed in section 6E below, Mehren complained to Kalmbach about the Justice Department antitrust suit against AMPI, which had been filed 2 days earlier. This was preliminary to further discussions in March and early April which, it is alleged, resulted in an effort to link further contributions to a favorable resolution of the suit. End of section 34. Recording by Linda Johnson.